order to have you avoid probate with it. One of the questions, McAvoy's actually asked this one. McAvoy's are some folks who've been to my little boot camp, I think twice. By the way, a lot of you do not know that I do a 2-day boot camp. It's very exclusive. We have a very small number of people there, and we roll up our sleeves and get down to nitty-gritty. And if you're interested in that, call the office, and we can get you on the list and notify you as to when our little boot camps are. But we only have a handful of people, and we make it pretty exclusive. If you've done your living revocable trust or your will or whatever it is, at the top of it says, I'm Mary Jane Doe, and I live in, I'm a resident of Palo Alto, California, and so on and so forth. If you move to Nevada, your will is still valid. If it says it's going to be governed under the laws of California, then we may have to apply California law, even though you're in Nevada. But technically that stuff at the first where it identifies you is just to identify you. And if we can establish that you were that guy at one time, the fact that you've moved doesn't invalidate your trust or any such thing. Had a question on foreign properties, and I'm going to beg off because I just don't know much about foreign properties. I don't know what the probate proceedings are in other countries. Canada I'm fairly familiar with. The tax implications, these are things that you need to think about if you have property in foreign countries. Certainly wouldn't hurt to put it in the U.S. trust, but whether or not that has any effect in the foreign entity or the foreign country, I couldn't tell you. They didn't ask which country it was in, so I couldn't even look it up. Funding your trust. How do I put my accounts into the trust? Well, you've got your bank accounts, you've got your brokerage accounts, you've got your safe deposit boxes, these type of accounts. What you're going to do is you're going to go down to the bank and you're going to take a copy of the trust or a copy of the certification of trust with you down to the bank, and they're actually going to take a copy of this certification. The certification is just a 2- or 3-page summary of your trust. If you don't have one, take the whole trust down. And they'll take a copy of the first page and the last page and powers of trustee or something in between. But they want to see that there is a trust, and then you're going to change the name on the account. That means you make out a new signature card. If it's a checking account, you just make out a new signature card, and you make it in the name of the Lee Phillips trustee for the Lee Phillips Living Revocable Trust. Actually, you make out your card, Lee Phillips Living Revocable Trust, and then you, down the side of the signature card of the bank, you'll notice there are a bunch of little boxes: corporation, partnership, trust, joint tenants, tenants in common, and you just check the trust box, and then when you sign the signature card, you sign it Lee Phillips Trustee. And now you don't have to change the checks. Anything can be printed on the checks. By the way, for identity theft stuff, you probably ought to just have your initials on the checks these days. But you shouldn't have to print new checks. You shouldn't have to open a new account. It shouldn't start the clock over on your account. If you've had your account for 6,000 years, it should still be a 6,000-year account. Everything should be the same. I did run onto somebody in Louisiana the other day that was having a problem talking the bank into doing this. 25 years ago, everybody had a problem doing it, but they don't now. It's no big deal. The banks all know about it. And if you're in Louisiana, you just don't have any law, so don't worry about it anyway. No. Louisiana is actually based upon Napoleonic or French law rather than the British law the rest of us have. At any rate, how do you move property into the trust? What forms do you use? There aren't any forms that you use to move property into the trust. The question is, what's the piece of property? If it's a piece of land, then you're going to have to make out a new deed, and that deed will transfer it from whoever the owner is now, you and your wife, husband, joint tenants, to you and husband-wife as trustees of the beautiful Bush Trust. whatever you named your trust. By the way, it's the beautiful Bush Trust under agreement, U/A, that's under agreement, 9/29/2010, whatever the date was that you signed the trust on. So we don't have any magic forms. At the back of the trust, you're going to see a schedule, and the schedule transfers everything into the trust. The schedule is primarily a myth. I don't really want you to rely on that schedule. Yeah, legally it will transfer your bank account into the trust, but practically it will not, because you're going to show up, your heir is going to show up at the bank and say, hi, Dad's dead, I need to get into the account, this is a trust account. The bank's going to say, well, gee, I don't know that this is a trust account. Go get me a court order. Go probate the account and tell me that it's a trust. Prove to me that it's a trust account. Whereas if Dad has gone down, they've got a copy of the trust. Dad signed the signature card saying it was a trust. Then the bank knows that it's a trust, and there isn't going to be any probate or any problem. So don't rely on the Schedule A or whatever it is that is attached to the back of the trust when you write the trust. That isn't going to get you too far. Just don't do it. What property do I put in the trust? Well, you put all property that you have to sign your name for. You don't have to sign your name to sell the washer and dryer. You just take it out, put it on the front lawn. Whoever pays you, they walk away with it. There's no title. Car, there's a title. Bank account, there's a title. Safe deposit box, title. Your piece of real property, there's a title. It's called a deed. So if you have to sign your name, the stock certificate, if you have to sign your name to transfer the property, then the trust has to own the property. So that technically when you die, the owner of the property didn't die. The manager of the property died, and our contract, our trust, says that you've named your oldest son as the new manager. So everybody will deal with your son once you are dead. Unpaid mortgage. Can I transfer my house into the trust if there's a mortgage on it? Yeah. You still owe the bank, and federal law says that you can transfer it into the trust. They can't call a due on sale clause. They can't do anything to you. Now, that's provided that it is a grantor trust. Let me give you the definition of a grantor trust. That means I'm the guy that sets up the trust. I'm the guy who's the trustee, and I'm the guy who gets the benefit while I'm alive. If you hold all three of those positions, grantor, trustee, beneficiary, then it is what's called a grantor trust. And federal law says if it's a grantor trust, they can't call a due on sale clause. Okay, if you move it into a land trust and you have your buddy be the trustee and your LLC be the beneficiary, that's no longer a grantor trust. The mortgage company can certainly call the due on sale clause. Now, they're not going to do that until interest rates get to be 45% next year. I think interest rates are going to go up, in case you really want to ask me. But if they do hit 15%, the banks are going to be looking for this sort of thing because they can close out that mortgage that's at 4.5%, and they're going to want to do that. But if it's a grantor living revocable trust, by law, they can't do it. So mortgage in my name, it's still going to be in your name. Federal law says that if it is a grantor trust, there's no tax implications. You still file your 1040 just like you always did. Moving assets into the trust, we've talked about real property. I've talked about John Doe as trustee for the whatever name you want to do under agreement, UA, whatever date it is. No tax consequences. There are some states, if you're in Florida or Texas, you have to worry about making sure that you keep the homestead for your personal residence, even though it's in the name of a trust. If you're in California, you've got to notify the state that you've moved it into a grantor trust. Remember, federal law says California can't do anything to you, which means they can't implement Prop 13 and increase your property tax just because you changed title on your piece of property. So if you don't notify them, then they're going to say, hey, property title changed, we get to up the property tax. We've talked about the bank accounts. By the way, all of this is covered. Funding the trusts is the last half of CD3 in the accumulation preservation of wealth set. And I actually had one question. A guy who obviously didn't have the materials sent in a question, where do I get information on trusts? Are there forms on trusts? And yes, there are forms, there's information. There's 16 hours of information on that. If you don't already have it and want the materials, call the office, the 801-802-9020 down there. What happens when the grantor of the trust dies? That was one of the questions. Well, this is Lee. I wanted you to take time for your family. I'm going to say enjoy the moment. That's a weird thing to say when somebody in the family has died. But it's in a way, it's a special time. The family's going to come in from all over, people you haven't seen in 60,000 years. You only see them at weddings and funerals. Spend some time with them. Take time to be with the family. You don't have to slice your wrists and run around doing anything for the first few days. Just take the time, mourn, celebrate the life of the individual. You are going to have to notify Social Security. That's one of the first things you should do. So you stop Social Security payments if they're coming in. By the way, you need a bunch of death certificates, and the mortuary is going to help you go through all of this. Make sure you get a number of death certificates. It's cheaper and easier to get them one time than it is to keep going back to the trough and trying to get more. But if the trust is correctly funded and stuff, there isn't going to be any probate. You don't have to worry about that. There's no courts. There's no lawyers. Sometimes in the trust or the will, the lawyer writes in there, immediately call me upon the death. And if you've got a living revocable trust and it's doing what it's supposed to be doing, you kiss the lawyer goodbye. You never see this dude again. In fact, out of all my clients, I've never had anybody go through probate yet, provided you've set up the trust and you used it properly. And obviously in the CDs, I teach you how to use it properly. So you've got to administer the trust after the guy dies. The new trustee comes in. They're the administrator. They read the trust. The trust is going to tell them what to do. They collect all the property. They divide it equally amongst the kids. Whatever the trust says to do, they need to do. If they don't do it right, the other beneficiaries can come back and sue them. So you need to do it right. You have to get a tax ID number for the trust, because when you die, your trust is no longer revocable because you're the one that gets to revoke it. If it's not revocable, then it's irrevocable. That means it's not a grantor trust. It's not revocable. You're no longer the trustee. You're no longer the beneficiary. So it has to be its own taxing entity. You'll have to get the trustee. You'll have to the successor trustee will have to get a new tax ID number, go down, set up a new bank account, start bringing the assets into that bank account. And by the way, just because it says pay everything out doesn't mean that you pay it all out. You need money for quite a long period of time. You've got to pay appraisers. You've got to pay the guy to keep cutting the lawn at Dad's house. So you need money to operate the property, to keep it there. You're going to file a final tax return. That can be filed at any time after Mom or Dad dies. That's a personal, that's the 1040 return. You just check the box on it. It says this is the final one, Dad's dead. Now you're not filing the final tax return on the trust when you've marshaled all the assets, brought them together, wrapped up, sold the house, divided the money, closed the bank account, and then file a final tax return for the trust. So that's what you're doing.